Hey everybody, how's it going? Welcome back to Copper Jacket TV. So today I'm going to start this video off with a question, and I want you guys to answer this question in the comment section. How is it that a judge, who I presume has been trained in constitutional law just based on their occupation, know less about the Second Amendment than you or I? The only answer that I can come up with is they don't know less than you and I. They're just simply activists, and they don't care. They don't care about what the Constitution actually says. They care about their own personal agenda. And that's exactly what we have here, where a judge has decided to side with the state and say that the state's interests are more important than your rights and deny an injunction. It's absolutely sickening when you hear the story. So let's talk about what happened. Now, first off, I just want to say thank you all very much for watching. I really do appreciate it. Majority of the people that watch these videos are not subscribed. So if you have a quick second, hit that subscribe button, that little bell notification. Those are two free things that you can do that would help this channel out quite a bit and help us spread the word about the Second Amendment. So this case was brought forth by my good friend Edgar Salazar, Guardian Arms, and the Silent Majority Foundation in an attempt to overturn HB 1240, which is Washington State's so-called, assault weapons ban, as it is clearly unconstitutional. As a matter of fact, it is so restrictive, I don't see how any judge could see that it is constitutional. Now, we have, as a matter of fact, multiple cases that are going on trying to fight HB 1240. This is, I believe, the second denial for an injunction in a row. Now, in order to understand why these judges are not granting injunctions, I can simply read you a quote from one of the judges, and it will help you understand what's going through their mind. And it might even shock you, because this is very Ninth Circuit stuff pre-Bruen. I mean, it states interests over your rights hand and foot. Now, buckle up for this quote, because this one's pretty much out there. This is a judge that ruled to deny an injunction in one of the cases that's moving forward in that state, where he writes, "Considering the exceptional dangerousness of these weapons, the public interest in their regulation by the state outweighs the plaintiff's desire to purchase more, again, quote-unquote, assault weapons. In light of recent mass deaths caused by assailants using assault weapons, it is appropriate for government bodies to find ways to protect the public from dangerous weapons within the limits of the Second Amendment," end quote. So basically what the judge admitted in that quote is that in Washington, they're still using the interest balancing approach. They're basically weighing the state's interest in public safety against your rights, and they're willing to let the state infringe on your rights as long as it has some type of an effect for the state in public safety, which is exactly what Justice Clarence Thomas said that you're not allowed to do in his opinion in Bruen. Justice Thomas, in his opinion, basically said that the courts are no longer supposed to use the interest balancing approach. Instead, they're supposed to use text, history, and tradition. So they're supposed to examine the text of the Constitution, the text of the Second Amendment. They're supposed to see if that law violates the text. They're supposed to look at the history and tradition of firearms regulations in the country, and then they're supposed to determine from that whether or not there's any type of historical analog that supports the law that you've created or are trying to create today. If it doesn't, it's immediately unconstitutional. If it stops at step one, it violates the text, it's unconstitutional. If there's no history and tradition, it's unconstitutional, right? These judges haven't mentioned that at all. They're just simply saying that the state says that this is for public safety. We believe that it's for public safety, and so we're going to go ahead and let them violate your rights. And so I ask again, how is it that a guy on YouTube and the general public out there watching this video right now knows more about the Second Amendment and Supreme Court precedent than these judges do? Well, it's very simple. They want to ignore it because they don't like it. They don't like the outcome in Bruen. It changes everything. It changes the game for the entire country, right? I mean, Bruen basically overturns a majority of gun control in the entire country. They see that, they don't like it, and so they're just going to go ahead and stick with that interest balancing approach. But what they don't see here is the long game, okay? Just like Gavin Newsom in California, or Hochul in New York, or Pritzker in Illinois, or Inslee in Washington, these people do not see the long game that we're playing, right? Which is basically to get these things overturned, banned, period. And so what's going to happen here is that as these lawsuits go up to the higher court levels, and the courts are more and less inclined to follow Supreme Court precedent, things are going to turn our way. And if it goes up to the Supreme Court, ends up going up to the Supreme Court, they've already said, they've already chimed in on this multiple times, as a matter of fact, on where they stand on Second Amendment rights. So if it makes it up to the Supreme Court, especially with the makeup of the court today, I think that a lot of these things are going to be overturned. Not to mention, we have a case that's already progressed in California, right? It's sitting in front of Benitez. It's been sitting in front of Benitez for quite some time now, and we're all waiting for him to, give an outcome in that, but that's a case that involves the Ninth Circuit, which also covers Washington. So if that case was able to progress and they were able to get California's ban overturned, that would have a direct effect on Washington as well. It would basically overturn HB 1240. And so again, there's a lot of different cases out there spread amongst these district courts that could have effects across the country post-Bruen. But again, you're seeing that a lot of judges here are simply denying and defying the Supreme Court. Then they're just doing things on their own regardless of precedent. So it's really shocking to see, especially given the fact that this judge ruled from the bench. Judges don't usually rule from the bench very often, right? Just like Benitez, he's got the mag ban, he's got the other ban currently sitting in front of him. He sits there and he's going to think exactly what he wants to write. That's probably why it's taken so long, because it's going to be word for word perfect, so that if there's an argument against his decision, it's going to be almost like an unbreakable barrier. I think that's what he's doing. He's choosing every single word correctly so that when this moves forward, it's going to be unbreakable. Now, judges ruling from the bench, however, mean that they just looked at it, they see the merits, they see the arguments from both sides, and they just decide to rule based on really their own opinion. They're ruling from the bench without any further, arguments on the matter. And that's it. So just that alone shows you that it's really more of an activism thing than it is an actual, legal conclusion. So anyway, I wanted to let you guys know about that. Another injunction denied in the state of Washington over HB 1240. It's getting absolutely ridiculous now, and I think that these activist judges need to be reined in, and they need to start maybe remembering what they were taught in school, and that's that the Constitution is the law of the land, and nothing else is above it. So anyway, I want to thank you all very much for watching. I do appreciate it. Please like, subscribe. You guys have a great day.